people, we're bringing up Gwen's Law, and I just want to tap into that while we're here. Gwen's Law isn't a national thing. Gwen's Law is something that's specific to here.
To Louisiana. Yep.
Yeah. So that was something that I learned when I came into this market, because I didn't understand why somebody would be on hold when they got to arguing at the hotel. Because I get a lot of transient clients that here for Mardi Gras, or here for whatever the parade, like the Boo Parade this weekend, and they get to an argument with their spouse at the hotel. Nobody leaked the blood, but whoever got arrested had to stay in jail 3 days.
Yeah.
Because of the Gwen's Law. And then sometimes, and you don't know, and then they don't really hold that Gwen's Law to a complete standard, because some people could get a battery on a dating partner, add strangulation, so it's a lot of strangulating in Louisiana. That was something new to this market too. So I catch a lot of those. So you could get the strangulation add on, or what they could say, enhancement. You could get the strangulation enhancement and still not get Gwen's Law.
Child endangerment. I hate it because it sounds terrible. But like the kids y'all could be way upstairs in another room. The children don't know what's going on, but because they were present in the home while this is happening,
or in the car,
wherever
I'm speaking from clients.
Yeah, but I'm just
I've had clients that argued at the gas station and they went to jail because the kids were in the car, and so they had child endangerment like 4 times because 4 kids were in the car.
And that was never the intention of how that statute would to be used, but that's how it gets used every day.
Right, because police are humans. And humans, humans make error, and then again, we talked about it's like a teapot. It just depends. We've all been through it. You've been all the way back to elementary, when you could, I'm gonna give my age here a little bit. When you was the class leader and you could write people's names on the board,
on the piece.
Whoever could write the names.
Who was talking while the teacher was
That's
out.
right. That person kind of went a little too hard sometimes. That person kind of got checked on the playground a few times, So I think, unfortunately, all across America, there are some police that have had a bad day, or that maybe shouldn't be police. And every now and then, the citizens find out with cases like this, an argument in a hotel that leads to arrest with a Gwen's Law enhancement, and then the police know how to give charges to keep you in jail.
Sometimes it's processed too, though, because the thing is that used to be back before any of us were involved in this industry, that police officers were given the discretion what they decided to charge, what they decided to arrest. And the only person that they'd be concerned about answering to would be their own personal conscience and maybe their supervisor. But now you'll see policies of, if there's a domestic violence call, somebody gets to go to jail. Somebody's got to go. And the reason why, no matter what. So, and it used to be way back that officers would say, if they didn't think an arrest was merited, somebody go take a walk around the block. Somebody go take a walk, cool off. But then leave it at that. Move forward. Instead, now they'll defer to the arrest, and that's by training and practice. That's not because many times the officers are not making a personal choice. It's what they're expected to do, because otherwise, if they don't, what their supervisors might call them out on is that if you don't do an arrest and something happens, then it's your ass.
So for clarity for people that are listening, and for myself, here in New Orleans right now, in general, if there is a call and there's a couple, and even if it's Dewan and I arguing, and the police get there, somebody has to go to jail.
So if they find merit that some form of domestic violence may have occurred in some form, or if they're not sure, they will oftentimes be directed to defer to doing an arrest or issuing a summons, taking some type of official action. So then that way they can document that they responded, document that they took action of some form. So that way if anybody's going to question their actions later, they can say, no, I did something. I did what I was supposed to do. I didn't ignore something or miss something. Because that's what they get accused of later. And that goes back to the whole idea of letting outliers dominate the actual conversation.
Right.
Because not every situation requires an arrest.
Right.
Not every situation requires the most extreme actions. But people then hear about the guy the guy or girl who was encountered by police officers multiple times for allegations of domestic violence, or hears that person allegedly, that couple that had officers respond to the location
Right.
10 times during the course of their argument, and then when officers didn't take action, then they get criticized or sued or called out for not taking action, even when those previous times it may not have merited action.
Right.
But now that they're getting criticized for it, now it's going to the other extreme.
And I think listeners should know that that there are certain things that they need to walk away from just by what you're saying. If we're arguing, and it's getting heated, I've had male clients that have had aggressive female partners.
Oh yeah.
And they have what they described as attempted to protect themselves from the fight, that the female, like if their girlfriend swung on them or hit them, they may say they just held her hands, or they just pushed her in the corner and just tried to get her, what you would think you would do in a certain situation.
For sure.
But that takes them to jail. And I think that it's good that you brought it and said it, so that we can actually talk about it and say, no, just leave. Because they really think, oh, I didn't hit her. I never hit him. All I did was hold his hands. You can't even
avoid that. Like, because they will stop you from leaving. I've heard so many instances where women are blocking the door, where the man is trying to leave, and then you can't stop a human being from being human in terms of, like, you keep doing this to somebody enough, they gonna snap. Like, they gonna...
Well, it's a reflex. I told people that you slap a 2-year-old in the face, you getting slapped back. If you hit me, and we're talking, we're adults, we can talk about it. I'm like, Stravros, did you just hit me? But if you hit a 2-year-old and if you hit the right person in the face at the right time, they hitting you back.
Yeah.
It's reflective, of what happens. But a lot of people, even clients that I've encountered, which hindsight is 2020, have thought that they were de-escalating a situation by holding the hands of the person, and then found themselves in jail here with a Gwen's Law for 3 days, and nobody ever got hit. And this information, again, is free.
Or circumstances where, thinking about how we were raised, corporal punishment is not something we talk about a lot now. But when I was a kid, sometimes I screwed up. Sometimes my dad or my mom might crack me one, just because if you're messing up, you need to learn. And sometimes just telling you doesn't necessarily do it. Obviously, there's ways that can get extreme, and where it goes from being normal to being very wrong. But I had a situation with a case that we handled a while ago, where daughter, 16 years old, was being disrespectful to mom. Mom was not listening, was acting out. Mom takes away the phone as a punishment. And the daughter, rather than reacting normally, proceeded to attempt to grab the phone and wrestle the phone away from mom. And when mom didn't let it go, daughter proceeded to be hitting on mom to try and get the phone gone, get the phone out of her hands. Mom cracked her as a punishment in response, because her 16-year-old kid was not listening, was being disrespectful, was hitting her to get and acting out to get what she wanted. Mom didn't hurt the child. There was no injuries. Mom went to jail for domestic abuse, battery, and cruelty to a juvenile. On her own child, under those circumstances that were understood and known to by the police officers. And she sat in jail for a Gwen's Law, had to be bonded out, had to defend herself to ultimately get to a result. And the spirit of the statute is not always being applied in these situations, and people apply it literally without really thinking about the consequences of going through. just because it's easier to do it that way and then they're covered, no one can say that law enforcement didn't do their job. You'll hear it oftentimes stated, we're going to let the courts handle it. We're going to let the DAs handle it. We take our action, now it's out of our hands, and it's no longer our problem. And that's really that's a failure in that system and a breakdown.
Right. Yeah. And so many households have dealt with it in one way or another. And they don't even, again, conversations don't happen. You don't know until you know. How there was a story recently where a mom took a phone from a child, like in Florida, he killed her.
Oh, I didn't know.
He killed her. Yeah, that was recent. Like, so you have to, I can't, I'm thinking of this at a 13-year-old, and I just can't imagine because, my grandmother raised me, and it was, it was stenching cords and stuff they called back then. And if I had swung on my grandmother,
baby, I just got.
We would have never met.
Listen, if I look at my mama, a
yes,
certain way,
if I had swung on my grandmama about a cell phone, because we had a house phone, I done got with the house phone before with the cord. Like, let me just grab this and swing. So, goodness gracious. And we've been talking about some things, and I don't want to get too far ahead without us tapping in back on these guns that are close to schools and daycares. Because Stravros, you and I talked about a case where a client had a gun in their home, but they were still charged with a crime, even though I thought you could have a gun in your house to protect yourself. But in certain circumstances.
So the thing is, you are allowed to have that gun, and we're still handling cases like this now. And the thing is that technically, this is a conflict of the laws. All the new laws that came out related to protecting your Second Amendment and protecting your right to possess a firearm, they're here. But then there are the statutes that say if you possess a firearm within 1,000 feet of a school or a gun-free zone, you get to go to jail between up to 5 years.
5 years?
5 years in jail.
Just for possession, not brandishing, not pointing and aiming.
Just possessing it.
Okay.
And the thing is that there's a disconnect between those statutes because if you're intending for people to be able to possess their firearms in a reasonable manner, and they are lawful, they are not felons, they are just living their lives. And then you're going to arrest somebody for possessing a firearm in their home when they live within 1,000 feet of a school zone. There's a disconnect there. And the problem is that rather than common sense would say if somebody's not using the gun in an illegal or wrongful manner, to leave them alone, and instead to bring them and put them in jail for that, when there's no reasonable reason that somebody who's in their home shouldn't be able to do what they like in their home. You get situations like this where now you have to go to court and defend a situation that's a little absurd.
Right.